95-EL-BGN, which is captioned in the matter of the application of Republic Wind LLC for a certificate of environmental compatibility and public need. My name is Jay Agranoff, and with me is Anna Sagnol, and we are the administrative law judges assigned by the board to hear this particular case. Pursuant to the entry of September 12, 2019, the evidentiary hearing in this matter was scheduled for a call and continue on October 2nd, 2019, with the evidentiary hearing to reconvene today, November 4th, 2019. At this particular time, we'll take the appearances on behalf of the parties, on behalf of the applicant.
Good morning, Your Honor, and thank you. On behalf of the applicant, Republic Wind LLC, Devin Parham from the law firm Rickard Eckler, 100 South 3rd Street, Columbus, Ohio, 43215. And I also want to make appearances on behalf of my co-counsel, Mr. Dylan Borchers, Dane Stinson, Sumner Sheely, Elise Akbari, and Kara Hernstein, who will be filing a formal notice of appearance for some of those additional co-counsels.
Thank you. And why don't we just continue along the table? So,
thank you, Your Honor. On behalf of the staff of the Power Siting Board, Dave Yost, Attorney General, Jody Baer, Robert Eubanks, Assistant Attorneys General, 30 East Broad Street, Columbus, Ohio.
thank you.
Good morning, Your Honor. On behalf of the Ohio Environmental Council and Environmental Defense Fund, Miranda Lepla and Chris Tavener, 1145 Chesapeake Avenue, Suite I, Columbus, Ohio, 43212.
Thank you.
Good morning, Your Honors. Derek Devine, Seneca County Prosecutor, on behalf of Adams Township, Reed Township, Scipio Township, Seneca County, and the Seneca County Park District.
Thank you.
Good morning, Your Honor. On behalf of the local residents, I'm Jack Van Clay of Van Clay and Walker, 132 Northwoods Boulevard, Suite C-1, Columbus, Ohio.
Thank you.
Good morning, Your Honors. Amy Milam on behalf of Ohio Farm Bureau Federation, 280 North High Street, Columbus, Ohio, 43215.
Thank you. And just so that the record is clear, there are other interveners that have been granted intervention in this particular case. I do not see counsel for them, but I will note that York Township and then individual residents Dennis Hackenberg and Mike and Tiffany Kessler have all been granted intervention but are not in attendance today. Now, I know that pursuant to communications that have taken place over the last couple of weeks, we have established a witness schedule for this particular proceeding, and I will now just go over that particular schedule and make sure that everybody is still on the same page relative to the witnesses that we have slotted for the various days. For today, we have the applicant's witnesses Carr, Rice, and Old. For tomorrow, we would have the applicant's witnesses Lethwich, Munt, and Robinson. On Wednesday, we would have the applicant's witnesses Kurlinger, Mercati, and McGee. And then beginning on Tuesday of next week, we would have the applicant witnesses Doyle, Marus, Bulldozer, and Rupert. And then I believe we're going to have on cross witnesses that the applicant's going to call Sniffen and Wadsworth. And then beginning on Wednesday, we're going to have the intervener and staff witnesses begin with witness Kirshner, Chappelle, Shield Castle, Bose, Hoff, actually, there are 2 Hoff witnesses, and then Zeman, Wright, and Staines. And then on Friday, the 15th, we're going to have Siskowski, Betts, Newman, and Conway. Then on Monday, the 18th, staff witnesses Bellamy, Morrison, Zito, Collins, Pauley, Butler, Odell, and Conklin. Is that a correct representation of the witness schedule as council understands?
Yes.
Hearing no objection, we will presume that that is the order of witnesses that we will be proceeding with in this proceeding. For the purposes of just making sure everybody understands what our intended schedule on a daily basis will be, I know today we started at 10 o'clock in order to allow people to arrive in Columbus. But starting tomorrow, we will begin at 9 o'clock, and for each subsequent day, we will be beginning at 9 o'clock. We will try to at least get through, like for today, for example, Mr. Carr before a lunch break, and then each day we will try to take a lunch break for about an hour, and hopefully it's my expectation that we should be able to wrap up by 6 o'clock each day relative to the schedule in order to allow this to occur in an efficient and thorough manner. Any questions? I know that we had an early conversation regarding briefs in this matter, and I just wanted to make reference to the fact that, as we had previously discussed, we will finalize the briefing schedule probably towards the end of this hearing in order to allow everybody to better gauge what the time parameters might be with respect to briefs. There will be a time during this hearing where we will end up discussing information that has been placed under seal due to its confidential nature. If and when we get to that particular juncture, then only those individuals who have entered into the appropriate confidentiality agreements will be allowed to be in the room once we enter a closed record. I'm not sure, and I'm pretty certain that today we won't be getting to that juncture, but at some point later in the week, when that does happen, to the extent that there are, again, individuals in the room who have not entered into the appropriate confidentiality agreement, then they will have to leave the room, and also, as I had previously discussed with the individual who was doing the videotaping, that the videotape will have to be shut off at that point in time. And also, as I had previously mentioned off the record, there will be no live streaming of this hearing, so I would ask that everybody comply with that particular directive. I know that we had previously discussed some issues that council were still not in agreement on and would possibly need the bench's assistance in terms of resolution. Mr. Van Clay, I know there was a discussion that had taken place with respect to witness deposition fees. Has that particular matter now been rectified?
Yes, Your Honor.
Okay, thank you. And Ms. Bear, I know that there had been a discussion and actually a notice of appearance that had been made by counsel for the Ohio Department of Transportation, but yet that individual is not present today.
No, he would be with Mr. Staines, the witness, so probably next week. Do you want me to enter an appearance on his behalf?
Well, I am curious as to the extent to which the Ohio Department of Transportation intends to participate in this proceeding, and for what purposes.
The purpose is, if you've read Mr. Staines' testimony, is the airport testimony, and that would be the only role that the Ohio Department of Transportation would have, sponsoring that witness.
Okay. So from your perspective, then, counsel for the Ohio Department of Transportation has no intent to be cross-examining any other witnesses in this proceeding?
No, no
And-
cross-examination by them.
And has no intention of filing a brief
No,
in this matter?
no.
So again, that individual's participation is limited solely for the purposes of calling Mr. Staines and entering his testimony into the record.
That is correct, Your Honor, and pursuant to 490610, I forget which number it is, the Power Siting Board has to consult with the Ohio Department of Transportation, so that's the purpose of that witness.
Okay. I know that there are a number of pending motions, as Mr. Perrin had referenced earlier, and we might as well delve into those right now. Some are easier than others, so we can attempt to address the easy ones first, and then delve into the more contentious ones. Okay, the first motion that I have was filed on October 30th, 2019. It was the local residents' unopposed motion for leave to file direct testimony, and this was specific to the desire to file amended direct testimony of witnesses Sosowski, Hoff, and Chappelle. Are there any objections to the aforementioned motion? If not, the motion for leave to file direct testimony, and actually it's, I believe, the supplemental direct testimony, or an amended testimony is granted. The next motion that I have is filed by Republic Wind, seeking leave to file supplemental and updated testimony for witnesses Carr, Doyle, and Old. Any objections to the aforementioned motion? There being none, the motion shall be granted. Next, there are 3 motions that were filed on February 2nd, 2018, as well as 3 motions that were filed on December 26, 2018, all seeking protective orders of various exhibits to the application or portions of the application itself. And I do have some questions with respect to those motions. Specifically, if counsel for the applicant could provide me with some clarification. On February 2nd, 2018, the motions that were filed were with respect to Exhibit G, which pertained to the socioeconomic costs of the project, and Exhibit W, which were the safety manuals. I also noticed, though, that in addition to those motions, there is Exhibit P, for which I can't account for when looking at the docket card. Do you know whether Exhibit P to the February 2nd filing was ever included?
Can you give me a moment, Brian?
Sure.
Your Honor, rather than hold up the entire proceeding for us to figure this out now, can we possibly, when we have a break, take an opportunity to check and see on that exact exhibit from the initial application and then address it later?
Certainly.
Your Honor, that was Exhibit P as in Paul?
Yes.
Okay.
And that was with respect to the February 2nd, 2018 amended application. I would also note that you filed, in addition to the request for the protective status of Exhibits G, which was the socioeconomic cost discussion, as well as then Exhibit W, which was the safety manuals. And then you also asked for protective status of portions of the application, pages 33 through 36, which I believe also dealt with cost information. With respect to Exhibit W, which is the safety manuals, there is no redacted version of that exhibit. Is that a correct statement?
Yes, Your Honor.
Okay. I would ask that if you could please go back and review Exhibit W and see whether or not any of that information is currently available publicly on any websites or information within the industry for which a redacted version could be provided.
Yes, Your Honor, we'll review that and make a determination with appropriate redactions.
Okay. And if you could please do that within 2-week time frame.
We can do that, Your Honor.
Okay, I'd appreciate that. Then with respect to the December 26th, 2018 motion for protective treatment, you had again sought protective status of Exhibit G, the same cost estimate information, Exhibit W, which again was the safety manuals, and then the corresponding application information that pertains to cost information. I noticed that although for the February 2nd, 2018 filing, there was a redacted Exhibit G, but yet for the December 26th, 2018 filing, there was no redacted version of Exhibit G. And I would ask that to the extent that you are able to provide a similar redacted Exhibit G as you had for February 2nd, that you do so. And then with respect to Exhibit W, which again is the safety manual information, if you could please do the same type of exercise that we just discussed relative to the February 2nd filing and see whether or not any of that information can be provided on a public record.
Yes, Your Honor.
Okay.
Also, counsel, if you could just use your microphones because it's a little further away from you. Thank you. Just a little closer.
And then the other thing that I noticed with respect to comparing the docket card for the February 2nd, 2018 application to the December 26, 2018 application, I don't see an exhibit H, M, N, P, U, or V that is part of the public record. So if you could please also check on that and report back as to what the status of those documents are, because your motions for protective treatment don't address H, M, N, P, U, or V.
We'll check on that, Your Honor.
Okay, thank you. And if you could possibly, by tomorrow morning, just let me know the status on those exhibits.
Yes, Your Honor.
Thank you. Okay, with respect to the motions to strike that are pertaining to specific portions of various witness testimonies that have been pre-filed in this case, we will deal with those specific motions at the time that the particular witness for which those motions correspond. When that individual is called to testify, we will deal with those motions at that point in time. However, I do know that in addition to motions to strike for witness Carr and witness Munt, the local residents have also filed a more broader in scope motions to strike the testimonies in the entirety for witnesses Carr, Doyle, Curlinger, Leftwich, Mercati, Morose, McGee, Munt, Old, Rice, Robinson, Rupert. And with respect to those requests, we will deal with that at this juncture before we actually call the first witness. So at this point in time, Mr. Van Clay, if you would like to elaborate on.
Sorry to interrupt, Your Honor. Actually, today we filed a memorandum in opposition to the motion to strike / motion to eliminate the local residents. I have additional copies for the bench and the parties. We're prepared to make oral arguments on the motion, but I want to be able to provide that to the parties here today.
Okay.
Your Honor, with respect to the more general part of our motion, since the time that we filed this motion, Counsel for Republic has produced a substantial number of documents that and has represented that they have produced all of the documents that we have requested. And based on that representation of counsel, we are withdrawing that portion of our motion and eliminate at this point.
Okay.
Your Honor, so may I ask just a clarifying question? So proceeding forward, the two issues that will be addressed through the local residents motion will just be that portion specifically striking Mr. Carr's testimony and then Mr. Munt's testimony. Is that accurate?
We would be dealing with those two remaining issues at the time that those individuals are called to testify, assuming that, Mr. Van Clay, those two are still fair game?
Yes, Your Honor.
Okay. And are you, Mr. Van Clay, are you then saying basically then that with respect to the memoranda contra that Counsel for Republic just provided us, that all of these issues then have been resolved, or does this go into the issues of witness Carr and witness Munt as well?
The memorandum contra does address specifically Mr. Munt and the motion to strike his testimony. There's actually a indication within our memorandum that with respect to Mr. Carr's testimony, when he gets on the stand, I think we may have revisions to his testimony that will actually address Mr. Van Clay's motion. And then the rest of our memorandum in opposition deals with the remaining 12 witnesses. So to the extent that Mr. Van Clay is withdrawing his motion for those 12 witnesses, I think the remaining dispute would be just that portion of Mr. Munt's testimony, which we can address once he's called his name.
Mr. Van Clay, do you concur with that representation?
Yes, Your Honor.
do we have any other motions that we may have missed? Going once?
Your Honor, on November 1st, Republic Wind filed a motion to file notice of project modification. We're withdrawing that motion.
Are you withdrawing the motion part of it, but still having the amendment be considered?
At this stage, Your Honor, it's not going to be considered in this case. So the consideration of the modification is not an issue.
Okay, so with respect to the particular turbine that the filing that you were just referencing pertains to, you're saying that whatever is currently on the record prior to the filing of this document is what will be under consideration?
We will not be filing a proposed modification, Your Honor.
Okay. Basically, then you're just withdrawing
Yes.
this filing? Okay. Anything else that we need to discuss before we call the first witness?
Your Honor, with regard to Mr. Carr's testimony, just wanted to let the bench know that we will have about 10 minutes of cross from Mr. Carr on confidential matters.
Okay.
And I would make a suggestion that given that Mr. Carr is still going to be on the stand by lunch, that perhaps we just excuse everybody other than attorneys 10 minutes before the lunch break, so we finish that up and everybody